Welcome to the Illinois Divorce Guide podcast, where we break down the complex and emotional process of divorce into manageable, easy-to-understand steps. I'm your host, Greer Howard, and with me is Bobby Buchanan, widely recognized as one of Illinois' top divorce attorneys, offering unmatched insight and experience in family law. Well, it is great to be back for another episode. Bobby, so nice to have you here today, and we are continuing a conversation that we've been having for the last couple of weeks. We've been talking about the temporary hearing for parenting time. And we have discussed in previous podcasts what to do to prepare for this hearing and what to expect, what happens during the hearing. And then today, we're going to talk a little bit about after the hearing and then also some very common questions that a lot of our listeners have today. So, Bobby, as always, so great to be here with you today. How are you?
I'm doing good. As always, I'm excited to talk about divorce and talk about this particular process because as we've talked about in the previous episodes, this can be nerve-wracking. You know, you're walking into court. You've probably never been into court, maybe for a traffic ticket or something years ago, but this is a lot different. This is about your kids, and it's it's scary. So the more that we can explain everything here, what to expect, who is who in the courtroom, how long this is going to take, break it down so maybe you can be a little bit more comfortable when you walk in. That's our goal with this whole series.
That's right. I love that. Well, why don't we talk a little bit about, we're going to kind of pick up where we left off last time. And so the hearing is complete and you have your ruling, you have your temporary agreement. So why don't we talk through some of the first things that you need to do and what it looks like to practically live this out?
Yeah, absolutely. So let's pick up kind of right when we rest, if you will, which is the legal term for we're done with the hearing in the courtroom. What should we expect to happen? Well, the judge is going to let us know whether or not they have a ruling right away. And sometimes they do, sometimes they don't. Sometimes they'll say, I need a week and I'll issue a ruling. But usually on these temporary ones, they can pretty much say, okay, here's what our temporary schedule is going to be based on the testimony, based on the evidence that we heard. So what's going to happen after that is that needs to be put into writing. And there's usually still some finagling that happens at this point where the judge will say, okay, I'm going to give mom Mondays and Tuesdays, dad Wednesdays and Thursdays, and then you guys are going to flip flop weekends. But they leave it at that. And they say, okay, I want you to go out in the hall now and figure out when the exchanges are going to be, where they're going to be. And the judge is hopeful that with that framework, at least the parties can figure out the rest. And if they can't figure out the rest, then they got to come back into the judge and say, Judge, we couldn't figure out where to exchange the child or what the transportation should look like. And the judge will make a ruling on those things as well. So that's kind of finalize everything in court. Now, what happens next is we have to follow that court order. The first thing that we want to be absolutely sure of is that we understand what the court order is. It's one thing to hear something in court, and you might swear that you heard one thing, and then you read the court order and it's something different. So it's crucial that we read that court order, that we understand what it says, because it does not matter what was said in court. Completely irrelevant. What is relevant is what's written on that order and signed by the judge. It should be the same thing, but sometimes we think we heard something that wasn't said, or things change going from what is said down to writing. Whatever it may be, we got to read that court order and understand what it stands for.
Yeah, definitely. And I guess, depending on your dynamic with your ex-spouse, those are opportunities where maybe if you had a hard time coming to, the agreement, that you can always go back and say, well, it says here on this document that we both signed that I'm picking up, this way, or this is my day. So it can help with like a lot of those little, just potential little fights, is to be able to go back to that paperwork. So I think that that's really nice to know. But like we said, this is a temporary agreement. So if there are things that maybe you don't love or don't seem to be working in the temporary agreement, what's the best way to handle that? Because I don't know that the best way is to really argue with your ex-spouse. I mean, you kind of at this point have to go by it, but what are some of the things you should be doing to maybe if you have to, go back to court later for the, what is going to be long term, what types of things should you be doing?
Yeah, great question, because the last thing we want to do here is not follow the court order, even if we're unhappy with it, or constantly be making issues about it with our ex. It is what it is. This is the temporary order, whether or not you like it, or you don't like it. So the way that we make the most of it and potentially set ourselves up for changing it is, one, be a great co-parent. Do everything you can to stay on good terms with your ex and make sure that this schedule works, and be a helpful co-parent. Let's say that you're the parent that wants more time. You were disappointed at the hearing because you didn't get as much time as you wanted. By staying on good terms with the co-parent, by being as helpful as possible, there's always going to be opportunities that arise to get more parenting time. That other parent, they have something that comes up. They want to go do something that doesn't involve the child, but it's on their parenting time. And so you can step up and say, no problem. I can take our kid, and I'll return him tomorrow morning. The more that you can volunteer and be that parent that steps in and is helpful, the better it is for you. You should keep track of those times. And eventually you and your lawyer will have a discussion about, like, hey, does it make sense to go in and ask for a modification? Because this is temporary. Modifications are easier. That being said, this temporary order is going to carry some weight, because the judge is going to look at it and go, well, is this schedule working for everybody? Does it make sense? Is it in the best interest of the child? So they're going to look at all those things, but you cannot intentionally sabotage this schedule and then go to the judge and say, hey, look, this isn't working. That's just not going to fly. It's a very, very risky and not advisable strategy.
Yeah, for sure. And you always mention, I want to just make sure we mention it here, is to make sure that if you are writing some things down, it's those facts, right? To not like the judge does not care about the emotions of this situation. The judge cares about the facts, correct, Bobby?
Absolutely. It's about the logistics. It's about looking at, how is this working for your child? You have to, when you go into court, you have to be able to point at things and say, this is what is happening and why I'm saying this is not in the best interest of the child. And it can't just be, well, I feel like it's unfair. Like, the judge doesn't have any time for that. So you really need to be able to point to concrete things that you are seeing happening. Maybe they're struggling with the exchanges, or they're not able to get into a rhythm as far as their homework or their extracurriculars, or their social life is kind of upside down because of this schedule. If we can point to those things, we'll have a better chance of modifying this down the road.
Yeah, absolutely. And I think we should mention, we're talking about this temporary parenting time and we have this agreement. And talk a little bit about the importance of making sure you're keeping the kids kind of out of any of the drama or any of the unhappiness, or because you really don't want the kids caught in the crossfire as you're figuring out this new schedule.
Yeah, that's the easiest way to sink your case, is if you start bringing the kids into this and maybe even complaining to them about the schedule that the judge ordered, making it seem like, oh, this is your mom's fault that we have to go through this, or this is dad's fault. You have to basically present to your child as much as possible that you and your mother are on a united front. Even if you battled it out in court and this is not what you wanted, what's best for the child is that you present this as if you're in a united front. And we can't unfortunately we can't control everything that the other side is going to say. There are some toxic parents out there who are going to try to alienate you from your child. My advice always is, stay on the high road as much as possible. It's, you might have to get a GAL involved later in the case to kind of unveil some of that stuff to the judge. You need to stay on the high road. Make sure that you are a role model to your child for how to interact in difficult situations. They're learning from you. It was like, if you have to deal with a difficult co-parent on the other side and you are as antagonistic as they are, then you're modeling for your child that that's how you deal with difficult situations, rather than being the diplomatic, compassionate one who's patient. Like, that's what you want to model. And the judge is going to see that as well.
That is so wise, Bobby. That's really, really good advice. Why don't you give us a couple of maybe practical tips? Because, I mean, just realistically, even for the parents, this is a whole new schedule, and they're having to get used to this new rhythm. So, what were a couple of practical things that can just kind of help them, stay organized and be able to kind of tackle this new arrangement?
Yeah, I think the shared calendar is probably number one. I know it's something that me and my wife do. I think probably most people do this, but it's even more important when you are in a co-parenting type of situation. If you can just have a calendar that clearly lays out what days are yours, what days are theirs, the extracurriculars that are going on, who's going to be making the exchanges, then that gives you guys a central place to go to when there's some sort of conflict, or you're saying, well, I didn't know about this. If you can both just rely on that shared calendar more and more, there's less areas for dispute and disagreement. So that'd be number one. Number two, keep your exchanges brief and neutral. Don't dive into issues that you might be having or things that aren't working. Like, that's one of the only times that your child gets to see you two interact, or that they are kind of forced to see you interact. So the more you can keep it neutral, especially if you don't have the best working relationship, the better. Now, if you get along great with your co-parent, or those, for some reason, or hopefully when you're in person, things do go well, then by all means, like, make it a joint venture. And, it doesn't have to be cool, like cold and calculated, but just be really careful about getting into any sort of disputes during that exchange. And then the last one is just regarding keeping your kids out of it. You want to let them know if they have questions about why are we doing this schedule. It's one, talk to your co-parent and get on the same page about what is our messaging to our kids. Are we telling them that this is what we came up with, this is what we think is best for now, even if maybe a judge is ultimately the one that made that ruling? Or are you both saying, we went to court and we asked the judge for help on this, and this is what the judge is saying the judge wants us to do now? Whatever that is, see if you can get on the same page messaging wise with the other parent.
Okay, well, these are some questions that we think all of our listeners will benefit from. And if you have any other questions you guys want to know, please just mention in the comments. We're happy to answer it another time. But Bobby, let's get started. So during a hearing like this, will the judge ask me direct questions?
So most of the time, the questions that you're going to be asked are going to come from one of two people, either your lawyer or the other lawyer. But it's certainly not uncommon for the judge, if the judge is listening to testimony and they're not getting a piece of information that they want, or the lawyer's not asking the question in the exact way that they'd like to hear it, they could interject and ask you a couple questions. So just stay calm. Just answer those questions as plainly and simply as you would if you were being asked by your good friend who's just curious and just
Yeah.
wanting to know. Like, these aren't trick questions. The judge doesn't have any preconceived notions. They're just trying to get some information from you.
Yeah, I love it. And you don't have to over answer. Just I like it's like direct and just calm, that's good advice. Okay, another question we have from one of our listeners is do I have to see my ex in the hallway?
Yeah, that can be uncomfortable, especially if the circumstances of your breakup weren't the best and you have a lot of feelings towards your ex. You probably don't want to have to see them in the hallway. If your hearing is in person, and some of these hearings are still on Zoom or, a video conference type of thing, but a lot of these hearings are in person. If that's the case, then yeah, there is a very good possibility that you have to see your ex in the hallway. And guess what? We got to get used to it.
Yeah,
Like,
that's to say.
co-parent, like, yeah, you're gonna have to see your ex a lot. So at least in the hallway of the courtroom, you have your lawyer, they have their lawyer. It's a very formal setting. Everybody should be on their best behavior.
Yeah, absolutely. Yes, you do have to get used to seeing your ex, because if you're there for a temporary hearing about your time with your children, then you're definitely going to be seeing them. Okay, so another listener has this question: can I bring my kids? Should I bring my kids?
Yeah, absolutely not.
Yeah.
This is a big no-no. Any judge that gets word that you brought your kids, the kids are in the hall, whatever, is going to be a little upset. And this is on the attorneys as well. Usually we don't have to tell our clients this. Most of us want to keep our kids as far away from court as possible. But sometimes usually this happens when a parent gets stuck and they just can't get childcare or something, so they have to bring their child. Really, we have to avoid this at all costs. So make sure that if you're in a jam regarding the kids, that you talk to your attorney and you guys game plan on how to approach this as best possible. But do not bring your kids unless you are explicitly told to by the judge or by your lawyer.
Okay. All right. The next question, I think a lot of people can have some fear around. What if their ex lies?
Yeah, this is a tough one, and this does happen, even if it's just like, hey, your version of the story is different than my version of the story. We're giving them the benefit of the doubt. But other times, some people lie. They're not bothered by just making things up or changing the truth a tad to make themselves sound better. What we need to do is stay calm. Your attorney should give you a notepad if you're at a table with them as you're listening to the testimony. Make sure that you write down those instances and give them to your attorney. They might ask you some questions about them, and then it's your attorney's job to expose those lies or contradictions in their testimony. That's what cross-examination is. So your attorney is going to have that chance to ask them questions and box them in a corner. And hopefully, if your attorney is skilled at cross-examination, they can expose some of those lies. You'll also be able to expose some of those lies later, because this hearing, if you have a court reporter, there's going to be a transcript of it. And so they're really locking themselves into a certain answer. They've sworn to tell the truth, and then they're telling the certain version. Well, if they change their story down the road, they can be what's called impeached by that testimony to say, hey, you said this earlier, now you're saying that. Obviously, you're not very good at telling the truth. And the judge will definitely look at that and start to not believe your ex as much. But we're really getting in the weeds here of litigation. Hopefully, this sort of lawyering doesn't have to happen in your case. But if your ex does lie, that's the mechanics of it.
Yeah, never a good idea to lie in court. Let's just highlight that one right here if you don't remember anything else. Okay, so our next question from one of our listeners is, will the judge read my long statement? And I think maybe for those who aren't familiar with what a long statement is, maybe you could also just clarify that too, Bobby.
Yeah, absolutely. So in different parts of a case, we might make a statement or have an affidavit, or maybe in our motion, we lay out some very detailed things that have happened or events that have happened in this case. And the question is, will I be able to read this directly to the judge? The short answer is no. You can't just read something as part of your testimony. You can't even just give a very long answer. That's going to be objected to as well. The court is going to say, or the other attorney is going to say, you're testifying in the narrative, as they call it. So giving testimony is a very structured thing. Now, that long statement, your attorney should be able to get the bulk of it into evidence through your testimony. It might also be attached to a motion or entered into evidence as an exhibit, or something like that. So it really depends on the nature of that long statement, when it was made, and whether or not your attorney thinks it's even strategic to have the judge read all that. Because a lot of the time, what we think is important isn't. And it's our lawyer's job to really filter out the stuff that's unnecessary and get to the meat and potatoes of it all.
So another question we have here is, can I record the hearing? And I think it's also worth the question of, is it being recorded? Can I record it? Is it being recorded? What about that?
Yeah. So can you record it? No, there's very strict rules in court about whether or not you can record it, say, using your phone or something like that. I know specifically in Illinois, we are two-party consent state. So unless everybody's on the same page and agreeing that it's going to be recorded, it can't be recorded. And particular courthouses as well usually have just very strict rules of you can't be doing recording. All the recording is done in a more official way. There's usually a court reporter there that's taking it all down. Depends on the courthouse whether or not there's a court reporter in every courtroom or whether or not you need to bring your own. And your attorney will talk to you about whether or not a court reporter is necessary. A lot of times with these more brief temporary hearings, a court reporter isn't necessary. But if it's a very litigious case, if we think it's going to go on for a while and we do want that to lock the other side into their lies so that we can impeach them later, then yeah, we need to get a court reporter. But you should not be worrying about recording anything.
Okay. All right. Good to know. Okay. So another question we have, this is a really good one. Bobby, people a lot of times feel like, that they kind of approach it like they're winning the case, like someone's a winner and a loser.
Yeah.
And I think also they feel like their their parenting skills are sort of being ranked or judged. So the question is a judge going to choose one of us as the better parent?
Great question. I think this really speaks to like how we feel about what the judge's rulings mean. And if the judge doesn't rule in our favor, does that mean that I'm a bad parent or a good parent? The short answer is no. The judge is not making a ruling on what if you're a good parent or a bad parent. They're making a ruling on what's in the best interest of the child. Now, the judge will draw conclusions from how this hearing goes. And if you get on the stand and you're really ornery or contemptuous, or you just come off angry, pissed off at the other side, you're blaming the other side, the judge is going to look at that and go, well, this person probably is not the best parent to be facilitating the co-parenting relationship. And that's a technical factor. It's like, are you the person that's going to be really gracious with the other parent, making sure that they're included as much as you are? So if you represent yourself as someone who's very diplomatic and patient and gracious, that does better for you. But if you represent yourself that's, short-tempered, and the judge can see that just from your 20 minutes of testimony, that's a problem. And the judge is going to remember that. And the judge is allowed to draw conclusions based on that. So just be careful on how you present yourself.
Yeah, absolutely. Bobby and I were just talking about emotions and kids before we started recording this. And this is a perfect example of, learning when to be able to kind of hide or control those emotions and when to be able to let them go. And court is not the time to let them go.
Absolutely. I was talking to you about my 6-year-old and how he needs to learn how to control his emotions in certain circumstances. And it's a lifelong journey to learn all of that. And especially like you said, in court is a time when we really need to contain them. There's going to be so many emotions running through us. We got to compartmentalize, make sure that we are present. It's just like a job interview. You got to present the best version of yourself despite everything else that might be going on outside of that interview.
Absolutely. Absolutely. And just continuing to remember, keep the facts, not the emotions. Keep the facts, not the emotions. Okay, here's a good question. Should I try to speak up if my lawyer forgets something?
Yeah, so you're not going to want to like jump up and say something. Again, this is where the notepad that you have next to you is going to come in handy. Make notes if you feel like your attorney missed something, and pass it along to them. There's usually going to be another opportunity for the lawyer to get it in before the court hearing. Discuss with your lawyer and make sure that your lawyer is very clear on things that you want to get into evidence. If there's like some things that are very important to you, the lawyer might say that's not as important as you think. And I would really take the lawyer's advice on that. Usually what people are talking about here is they want to make sure the judge knows about, some incident that happened with the other side. Maybe they're always late to pickups, something that's like relatively minor in the grand scheme of things at this point, or maybe the other side was the unfaithful one. It doesn't matter. And your lawyer will let you know, like, hey, that's not as important as it seems, and here's why. Hopefully your lawyer is good at explaining that. But if they do miss something, write it down, get it to them, and then your lawyer will take it from there.
Okay. Another question we have is, how long will we actually be in the courtroom? And that makes me think, if a listener hears, it's a 10 a.m. motion, does it happen at 10 a.m. or could that potentially adjust as well?
Yeah, it depends on the judge and their courtroom. They might schedule your hearing for a day when that's the only thing scheduled, or they might schedule your hearing for a day when they have a regular court call, meaning you have to come at 10 a.m., but they have to run through all their other cases, and then you're not going to be able to do your hearing until 11:30 or noon. Maybe their cases before that take longer than they expected, and it's noon before they're done, and then they say, well, I'm going to lunch, and then you have to come back in the afternoon. Make sure that you're free the entire day. Like, take the entire day off. Maybe you'll get lucky and you'll be in and out of there in an hour, and then you can go enjoy yourself because you'll be emotionally exhausted and you won't want to go into work anyway. Take the entire day off. That's all I can tell you.
Yeah, that's really good advice. Okay, our final question here, Bobby, today. Is it appropriate to bring a witness?
If you've talked to your lawyer about it and it's that type of hearing, then yes. Otherwise, don't just the night before be chatting with your BFF and you're telling them how worried you are about this hearing, and they say, well, I'd love to get on the stand and tell the judge about how amazing you are and what a dirtbag the other side is. One, that's not a great strategy. And two, you can't just come in like it's a TV show and do a surprise witness sort of thing. It's really going to depend on what type of hearing this is. You have to give advance notice to the other side on witnesses. Usually these temporary hearings don't involve other witnesses. So talk to your lawyer about it. But generally speaking, we're not going to be doing witnesses at this point in the case.
Okay. All right. Well, Bobby, that concludes our listener questions for now. We've talked about a lot through this series. We talked about, kind of getting ready for the hearing, what to expect when you're actually in the hearing. And then also we talked about, kind of adjusting to that lifestyle after the hearing, plus some frequently asked questions. Anything you want to mention before we wrap up today?
I think we just go back to the lesson that I had for Luke yesterday, my 6-year-old, and that is control your emotions as much as possible, compartmentalize them, make sure that you are presenting yourself as the peacemaker, the diplomatic one, the one that's truly focused on the best interest of the child, and just hold on to that. That's your North Star, and you'll be okay.
Okay. Awesome. Well, Bobby, as always, thank you so much for all of your wisdom that comes with life and with divorce. So we appreciate that here today. And if anybody out there has any additional questions, if there's any topics that you want us to cover, please comment, mention below. We would love to make sure we're talking about the things that you are curious about. Thanks so much for being here with us, and we will see you next time.
Thank you for listening to the Illinois Divorce Guide podcast. We hope today's episode gave you clarity and support as you move forward on your journey. If you found this episode helpful, please subscribe, rate, and review us on your favorite podcast platform. Tune in next week for more insights and expert advice on the Illinois Divorce Guide podcast.